Good morning, everybody. Welcome to our webinar, Data Privacy and Brexit, what you need to know and what you need to do. So my name is Nick Phillips. I'm a partner in the IP team of Edwin Co, and I'm joined this morning by my colleague Selina Clifford, who's a senior associate in the IP team. I'm also delighted to be joined by Stephanie and Abraham from Toshiba, who will be talking to you a bit later about sort of technology-driven solutions in this area. So if we look at what we're going to talk about today, I'm going to get the boring legal stuff over with first. So Selina and I are going to do maybe 25 minutes on sort of a recap of where we are and why this is all so important. And then we're going to focus in on the changes that the UK leaving the EU has caused. So a look at data flows and also other changes, things like EU and UK representatives. Then we're going to pass over to Abraham and Stephanie. And as I say, they're going to look at things from a much more practical point of view, just in terms of how their technology can help you comply both with the GDPR and also with the changes that have been brought about by the UK leaving the EU. And then we're going to leave a little bit of time for questions at the end. And you will hopefully see, we're using this GoToWebinar product. There is a box in there where you can put in questions, and those questions will come through to us, and we'll take them at the end. I think is probably easiest here. So we're going to talk for about 45 minutes all told, I guess, and then leave sort of 10-15 minutes at the end for some questions. Right. Quick recap. Where are we? How did we get here? Well, I think as we all know, UK sort of officially left the EU 31st of January 2020, but really and truly nothing changed. We went straight into a transition period where everything was kind of preserved, the status quo was preserved, and it wasn't until actually 11 p.m. on the 31st December 2020 that things really started to change. So that's kind of the big date, always referred to, certainly in UK government circles, as IP completion day, implementation period completion day. But then at the very last minute, we also have this treaty between the EU and the UK. So we have the EU-UK Trade and Cooperation Agreement, which essentially sort of regulates the relationship between the EU and the UK post-Brexit. So we'll have a look at that as well and see how that relates to this whole data privacy area. I quite like this slide. I'm not sure whether it's a lawyer trying to work out what's happening post-Brexit, trying to follow the sort of the new law post-Brexit, or whether this is a client just pulling their hair out, wondering what they should be doing post-Brexit. But either way, there clearly are quite a lot of issues for business generally with the UK leaving the EU, but also more specifically, certainly for today, on the sort of data privacy side of things as well. Basic position is that when the UK left the EU, so ostensibly on the 31st of December last year, laws such as the GDPR, so laws that were brought into the UK by a regulation, kind of ceased to be part of UK law. So the EU GDPR, as we all knew it, stopped becoming a part of UK law at 11 p.m. on the 31st December. However, what the UK has done is it's largely taken all of those pieces of legislation, so all of those regulation-made laws, and it's transferred them over into UK law, usually referred to as retained EU law. So on the GDPR side, what we've ended up with is not the EU GDPR, but essentially a carbon copy of it, referred to as the UK GDPR, which is, as I say, largely the same as the EU GDPR. The main differences are really definition changes. So rather than referring to union laws or the union or the EU, we're obviously referring to the UK, but it is very largely it is very largely the same. What law applies? Well, you know, if you're a UK business and your business is purely UK centric, it's nice and easy. You've only really got to worry about the UK GDPR. However, you'll probably remember that in the EU GDPR, we have this sort of slightly unusual sort of grasping jurisdiction. So if you are a non-EU business, but you're doing business inside the EU, the GDPR would essentially encompass you. It would apply to you, even though you're not based in the EU. And that classically caught quite a lot of US businesses, perhaps businesses that were sort of operating e-commerce websites, which were targeting customers in the UK, in the EU, and the GDPR sort of extended out and applied to them. So what that means in practice is that if you are a UK business and you are doing business in the EU, and the specific terms are if the processing you are doing relates to the offering of goods or services to people in the EU, or relates to the monitoring of people in the EU, you will still be caught by the EU GDPR in relation to that EU business, in relation to the EU processing, but you will be caught by the UK GDPR in relation to your UK processing. So you're in this slightly odd situation where, in fact, you may have two different versions of the GDPR applying to you, one for your UK business, one for your EU business. Actually, not much of a problem at the moment because they are, as I say, largely the same. I think the problem might arise if the UK's version of the GDPR or the UK's law starts to diverge from what the EU has, and that means you're going to have to keep an eye on two systems of law. That's potentially one for the future, I think. I'll hand over to Celine just to talk about why it's also important.
Thanks, Nick. Yes, so I'll be taking you through the 6 data protection principles of the GDPR, and we'll take a quick look at the fines that have been issued by the UK ICO since the GDPR has come into effect. Next slide, please. So the 6 data protection principles really don't differ too much from the old Data Protection Act, and they're listed on the slide. However, a notable change brought in by the GDPR is that these 6 principles are now underpinned by the principle of accountability. And this means that not only are you responsible for complying with the GDPR, but you must be able to demonstrate your compliance. So in practice, and generally speaking, this means putting in place appropriate and effective policies, procedures, and measures. Next slide, please. So why is compliance important? Well, we all know that the GDPR introduced higher fines for infringement. The EU GDPR sets a maximum fine of 20 million euros or 4% of your worldwide annual turnover. And in the UK, under the UK GDPR and the Data Protection Act 2018, it's £17.5 million or 4% of your worldwide annual turnover. Now, businesses who operate in both the EU and the UK could potentially find itself subject to enforcement action and fines in both jurisdictions. Should there, for example, be a breach that compromises data belonging to both EU and UK citizens. So you do just need to be aware of this. And outside of these fines, there are other things to consider too. Failure to comply with the GDPR is likely to bring negative publicity and consequences, and this could have an adverse effect on your business reputation. On the flip side, compliance can be a powerful marketing tool, and many businesses are demonstrating to their customers or clients just how seriously they take data protection and will use compliance to their advantage. And you can probably tie this back to the accountability principle that I just mentioned. So accountability really enables you to develop people's trust in how you use their personal data, and it plays a vital part in your clients' or customers' overall confidence and support in your services. So being accountable will not only help you build trust, but it can help you mitigate enforcement action. Next slide, please. So I'm going to talk about the fines, and the fines listed on the slide are some of the most notable fines that the UK ICO have issued under the GDPR since it came into effect in May 2018. Now, the main reason for these fines being issued all relate to breach of security. And security together with unsolicited marketing are the areas that the ICO seem to be most concerned about. So let's briefly look at a couple of these fines in more detail. Taking the Marriott fine, the ICO fined the Marriott Hotel Group £18.4 million for an incident that involved exposure of guest records relating to around 339 million guests. And according to a statement published by the ICO, the vulnerability that led to the data being exposed is believed to have started in 2014 in the systems of Starwood Hotels Group, which was later acquired by the Marriott. However, the breach was not detected until 2018, at which point Starwood was already under the control of the Marriott Hotel Group. And in short, the ICO concluded that the Marriott had simply failed to undertake sufficient due diligence when it bought Starwood. So it's a good case that serves as a good reminder about the importance of GDPR compliance and having robust data security systems in place. Moreover, for anyone considering or is involved in an acquisition, due diligence regarding data and information security is something that shouldn't be overlooked. I think the other important fine worth discussing here is the British Airways fine. In BA's case, its fine related to a cyber attack which occurred in 2018 and led to over 400,000 BA customers and staff's personal credit card details being compromised. The ICO found that the BA had inadequate security measures in place at the time of the breach, and that it could have taken steps to mitigate and prevent the cyber attack. And some of these measures that were called out included things like granting limited access to applications, data, or tools to only those which were actually required, and undertaking more rigorous testing. And other things including like multi-factor authentication to protect customers' accounts. And luckily, Toshiba will be discussing the security aspects of processing in more detail later on for us. Next slide, please.
Yeah, back to me. Thanks, Lena. Right, data flows. So the position has always been, and this is sort of pre-GDPR as well, is that the transfer of personal data outside of the EEA is a restricted transfer. So essentially what that means is you can't transfer personal data outside of the EEA unless, and there's kind of three unlesses. The first one is if the country that you're exporting it to has got an adequacy decision in its favour. So essentially what that means is if the EU Commission has said that that country affords an adequate level of protection for personal data, essentially. And there are currently 12 countries that have adequacy decisions, and they are countries like New Zealand, Argentina, Israel, countries like that. Come back to that in a second. The second way that you can transfer data outside of the EEA is if you put in place what's referred to as an appropriate safeguard. And again, we'll come back to that in a second. And then there are some other exceptions referred to as derogations, which you can occasionally use as well. So that was kind of the old position. Nothing really changes with the UK leaving the EU, except to say, and I suppose fairly obviously, that the UK is no longer part of the EU, and therefore it becomes what's referred to as a third country as far as transferring data is concerned. So whereas previously you could transfer data, say from France to the UK with no problem at all, because both countries are in the EU, with the UK dropping out of the EU, that's no longer on the face of it possible. So you've always got to look at these things two ways. So firstly, if you are transferring data to the UK from the EEA, you've always got to think of the fact that you'll probably need to get that data back at some point. So if, for example, you're using a data center, let's say you're a UK business, you're using a data center in France, every time you access that data in the data center, you're transferring it back into the UK. So essentially, you've got data whizzing both ways. So just thinking about transfers of data to the UK from the EEA, these will be restricted transfers. So you need to sort of find a way to transfer that data. Now, at the very last minute, the EU-UK cooperation treaty has sort of swooped in and given us a bit of a solution. And what that says, or what that does, is it creates a transitional provision. And it creates a sort of transitional period of 4 months, which will be extended by another 2 months to 6 months if neither party, so neither the EU or the UK, object. And during that transitional provision, so that transitional period, you can transfer data from the EEA to the UK, and it's really as if the UK had a finding of adequacy for that period. And the idea is that during that period, the EU Commission will be looking at the UK and deciding whether to grant it, effectively a more permanent finding of adequacy. Now, so that makes it quite difficult, because you've only got this short window, and you have to decide what to do. Our advice, and I'll talk about this in a bit more detail in a little bit later, is that the thing to do is probably to treat this transitional period as just that. Assume that it will come to an end, and at the end of the transitional period, you will need another way of getting your data from the EU to the UK. So what we are suggesting is that you start putting in place additional safeguards to ensure that you can continue to move that data post this transitional period. So transfers of data from the UK to the EEA. This has always been a bit more certain, because the UK government has always said that they will treat the EU, the EEA, at least provisionally, as affording an adequate level of protection. And they've said that that will be the position until at least the end of 2024. So you can transfer your data out of the UK to the EEA with a bit more certainty in the sort of short to medium term that's not going to change. And the UK has also said that it recognises the adequate protection of the 12 countries which the EU recognises as being adequate. And then just to finish that off, transferring data from the UK to other non-EEA countries, well, it's the same position as it's always been. That will be a restricted transfer, and you need to have one of those things in place. So you need to ask whether there is a finding of adequacy, or you put in place an additional safeguard, an appropriate safeguard, or you use a derogation. So it's a slide here on restricted transfers. I think I've probably been through most of this. A couple of things to pick up. Will the UK get an adequacy decision? This is obviously fairly important stuff. I think, and I wouldn't say the smart money, but I think the sort of the majority opinion has moved to answering that in the affirmative. So saying that it is more likely than not that the UK will get an adequacy decision at the end of this transitional period. I think the main thing that if I was the EU Commission, the main thing I'd be concerned about is the UK suddenly changing its laws, and I'd be concerned, for example, that the UK start recognising other countries as being adequate, and the concern there is that data of UK citizens or people in the UK, so in the EU, would move to the UK and then would be able to be transferred out to other countries, which will obviously affect the security of that data. But as I say, the majority opinion seems to be at the moment that the UK will probably get an adequacy decision. Another reason why we might not get an adequacy decision is there is a general concern over the UK's mass surveillance laws. Essentially, the UK government gives itself quite wide powers to intercept and to look at data, and that is a sort of a fairly common theme when it comes to looking at the adequacy of laws in other countries. And then just to mention derogations there, I would always see these very much as being the last resort. So if you've got nothing else, if you haven't got an adequacy decision, if you can't put in place an appropriate safeguard, you generally fall back on derogations. As I say, they're quite restrictively interpreted, and they really are for very occasional and non-repetitive transfers of data. Where you do see them quite a lot is where you are transferring data to a customer for sort of a one-off or fairly limited transaction. Derogations can be quite useful there, and I've set out on the next slide, and I don't intend to go through them in the interest of saving a bit of time, the various derogations. Note that nearly all of them require the transfer to be necessary. So it can't be a transfer which was just convenient or commercially expedient. It's got to be a sort of a transfer that was really required. Appropriate safeguards. I've set out a few there on the slide. I suppose the bad news is that the third one down, Privacy Shield, no longer works. There was a case which I'm sure most, if not all of you, have heard of, called Schrems 2, back in the summer of last year, which said that essentially Privacy Shield doesn't work. Privacy Shield was an agreement between the EU Commission and the US, which allowed US companies to sign up and essentially be given an adequate level of protection. So Schrems 2, the European Court of Justice, has said that Privacy Shield doesn't work, and it doesn't work largely because of the US government's mass surveillance laws. So Privacy Shield has been ruled to be invalid. I've also mentioned their certifications and codes of conduct. They are very much possibilities going forward. They're in the GDPR, except at the moment there are no approved certifications and there are no approved codes of conduct. So they're probably not in the running right now. So the field is narrowed quite substantially, and I suppose the only two real games in town when it comes to appropriate safeguards are binding corporate rules. which do take quite a lot of time to set up. You're probably looking at certainly 12 to 18 months at a minimum, I would have thought, and can be quite expensive, which leaves you with standard contractual clauses, which are pretty much the favoured way at the moment of transferring data outside of the EEA. Standard contractual clauses, if you don't know, are literally that. They are contractual clauses which have been approved by the EU Commission, and essentially you put them in place between the data exporter and the data importer, and the way they work is to sort of set up that system of providing an adequate level of protection. They're by no means perfect. There's a number of difficulties with them. The first one is they are now extremely out of date. They predate the GDPR quite considerably, so they weren't really written, well, they weren't written at all with the GDPR in mind. So they are a bit old. They are quite limited in application. There are forms for controller to controller transfers and controller to processor transfers, but nothing else. So if you're doing a sort of a processor to sub-processor, as often people are, there's no specific form for that. And similarly, if you're moving data back from a processor to a controller, maybe from a data center to a controller, there's no specific form for that. And just generally speaking, they're a bit unwieldy. It's difficult / impossible to get a sort of third party involved to sort of do a tripartite agreement, which you quite often will want to do. And it's also very difficult to include sort of business terms in them as well. So they're not the most user-friendly things in the world, but at the moment they are pretty much the best option. And I've set out here a few scenarios. I thought it might be just useful to go through one or two of these, just to sort of try and illustrate the issues around data flows. So I suppose scenario one is probably the easiest one. Here we've got a UK business, and essentially everything is happening in the UK. No data moving outside of the UK. It's got its data center in the UK, and all its clients and suppliers are UK based. So certainly in terms of data transfers, pretty straightforward. There are none, and it really would be just for that UK business to ensure that it's complying with the UK GDPR. Moving on in complexity, so scenario two, again, a UK business, data center in the UK, but it's got clients and suppliers in the EEA. So as I just said, at the moment, that data can be transferred out of the UK to the EEA because the UK government has said that the EEA is provisionally offers an adequate level of protection, and the data can also go back again due to this transitional period in the EU UK cooperation agreement. But this is here this is a sort of situation where you've got to sort of try and plan ahead a little bit, and you've got to think to yourself what's going to happen after 4 or 6 months. And as I say, the advice here is to start putting into place appropriate safeguards to ensure that you can continue to move that data in the future. So you probably need to be looking at standard contractual clauses for this sort of scenario, but I'll come on and talk about exactly how you might do that in the future. Scenario 3, again, a bit more international, data center in the EEA and clients and suppliers both in the EEA and outside the EEA. So data center in the EEA, that's a fairly common thing that we see. And again, it's the same as scenario 2, really. You've got data moving from the UK to the EEA. And then every time you access that data in the data center, you are moving the data back again. So you've got to think about how you're going to continue to do that post this transition period. And then in terms of data moving outside of the EEA, I suppose it does depend on where it's going to. If it's moving to one of those 12 countries who have a finding of adequacy, then great, no problem at all. You can do that with very little hassle at all. But if it's moving to a country such as the US, for example, or Australia, you will need to put into place an appropriate safeguard or rely on a derogation. And then just to finish off, scenario 4, UK branch of an EEA company, which is again very common. I see that quite a lot. And I suppose this is different because you will tend to find that there's quite a lot of data or the companies would like a lot of data to whiz backwards and forwards between the UK branch and the EEA company. Stuff like HR data is likely to be shared between the UK branch and its EEA parent. And again, as with scenario 2 and 3, you need to be thinking about how you're going to do that post this transition period. So that's the trick there. Right, let's move on. And I suppose ideally, I'd really like to stop there and say it's all about standard contractual clauses. There they are, no problem at all. But there are sort of 2 points of complexity, I suppose, which need to be mentioned here. The first one is Schrems 2 and what the European Data Protection Board says about that. And the second one is the fact that there are potentially new standard contractual clauses on the horizon. So in terms of Schrems 2, you remember I said that Schrems 2 had essentially struck out or made invalid the Privacy Shield arrangement between the EU and the US. In Schrems 2, the court also looked at standard contractual clauses, and thankfully they said, well, they're not invalid, which is great. I'm not sure what we would have done if they'd have said standard contractual clauses were invalid, but they've said that standard contractual clauses may by themselves not be enough, and you may have to do more to sort of bolster the protection that those standard contractual clauses give you. Now, and this is all around this sort of mass surveillance idea. So the idea is you look at what the law is like in your destination country, you look at what the mass surveillance regime is like, and you sort of plan accordingly. Now, the European Data Protection Board has set out a whole load of recommendations that it's kind of summarized into 6 points, which I've set out here. And it basically involves understanding where your data is going. And I think if you don't have that, the whole thing becomes extremely problematic. So you need to know where your data is going. You need to know, what your tool is for doing that. Are you using standard contractual clauses, binding corporate rules? Are you relying on a derogation? Then you have to look at what the mass surveillance regime is like in that destination country. You might need some help from the party you're exporting it to. You look at what supplementary measures are available and adopt them. Come back to that in a second. Formal procedural steps. In some circumstances, it may not be possible to put into place supplementary measures which are quite enough. So you might have to go back to your supervisory authority, and finally keep the whole thing under review. So it's very much a fluid situation, so that you are continuously looking at it and guaranteeing that appropriate level of protection, really. So that's what the EDPB have to say about it. In terms of supplementary measures, they classically split into 3 technical contractual and organisational. Really and truly, and I'm not just saying this because I've got Toshiba on the webinar as well, it's all about technical, I would say, and the contractual and the organisational measures are backing up the technical measures you put in place. So if you think about moving some data outside of the EU, the principal concern is that data will be intercepted by that foreign government, I suppose. And the principal ways to sort of stop that happening are to encrypt that data to such a level that even if it is intercepted, no one can crack the encryption essentially. Alternatively, you pseudonymize it, so essentially you make it such that if anyone does intercept it, they can't see any personal data. So you essentially anonymize it, you encrypt the key, or you send the key somewhere else, and what that means in practice is that you are protecting the personal data. And as I say, you back up those technical measures with contractual and organisational measures as well. Right. Quick mention for the new standard contractual clauses. We don't have them yet. There was a consultation at the back end of last year that finished sort of in December, and I haven't heard very much since. I know there was a large amount of interest in that consultation, so I would expect the European Commission are sort of going through the feedback that they received and are looking to make changes and hopefully to adopt these new standard contractual clauses. The good news is that the standard contractual clauses, or the new ones, are a lot more flexible than was previously the case. There are a number of sets of them, so as well as controller to controller and controller to processor, we've also now got processor to controller, which is obviously good for sending data back from data centers or accessing data from data centers. And we've also got processor to processor clauses as well, which would be jolly useful when it comes to processors appointing sub-processors. They're kind of sort of modular in the way they're set out, and they sort of do signpost you to taking into account the Schrems 2 factors. That they're not by themselves an answer to what Schrems 2 said, but they do help you, assist you in putting into place those supplementary measures that I've just been talking about. And as I say, generally they're just generally more flexible, a bit more user friendly. So very much watch this space on those new standard contractual clauses. Very hopeful that we will have them. Certainly, well, you would hope in the next few weeks, but I've been saying that for a little while now. So let's see on that front. I think it's back to Selena just to talk about other things that have changed with the UK leaving the EU.
Yeah, thanks, Nick. Yeah, so considering what else, I'm just going to run through these quite quickly, some practical points you should consider. So the first one is whether you need to appoint an EU or UK representative, or perhaps even both. So if you're based in the UK and you don't have a branch or other establishment in the EU, but you're processing personal data of EU citizens, then you will need to appoint an EU representative under the EU GDPR. Now that UK has left the EU, similarly, if you're based outside the UK and don't have a branch or establishment within the UK, but you are processing personal data of UK-based individuals, then you will need to appoint a UK representative under the UK GDPR. So there's potential that you need to appoint both if you're processing personal data belonging to both UK and EU citizens. And the second point here is to consider the end of the one-stop shop. The impact of the end of the one-stop shop on cross-border processing is something that needs to be considered by UK businesses. As a quick reminder, the one-stop shop was brought in by the GDPR and was designed so that controllers and processors in the EEA, which carry out processing affecting individuals based in more than one EEA member state, only need to deal with one single EEA data protection authority. So in essence, this means you are only investigated by one supervisory authority for any infringements or breaches, and would be issued with only one fine across the EU for any enforcement action. Now that the Brexit transition period has ended, businesses in the UK carrying out cross-border processing, and that is processing that affects individuals in another EU member state, may no longer be able to benefit from the one-stop shop. And in this case, you'll have to deal with both the UK ICO and the supervisory authority in the other EU member state where you are established. However, and perhaps a little bit confusingly, the one-stop shop will still apply if you are cross-border processing in 2 or more establishments in the EEA, and your processing is likely to substantially affect individuals based there. So for example, if you are cross-border processing in relation to 3 or more establishments, so 1 in the UK and 2 in other EU member states, for example, France and Italy, then cross-border processing will still apply across France and Italy, but not with the UK. In this situation, you would need to liaise with the ICO in the UK and have a lead supervisory authority from one of the 2 other EEA member states, so either France or Italy. Now, typically, the lead authority would be the member state where you have the largest customer base. And the last couple of practical points I want to just mention here relate to ensuring that your existing documentation is up to date and refers to the right legislation that applies to your processing. So you should ensure that your privacy policy reflects any of these changes. For example, it may now be the case that you need to update your privacy policy to identify any EU or UK representative that you've appointed and refer to either or both of the EU or UK GDPR. I'm going to hand over to Nick to summarise. You're on mute.
It was bound to happen once. Couldn't go through a whole without putting myself on mute. Apologies for that. Yes, this is kind of your call to action, your shopping list. Very quickly, you need to consider appointing an EU representative, particularly if you're a UK business doing business in the EU, and you may also need a UK representative if you are outside of the UK looking in, and I suppose you may even need both if you are, for example, a US business doing business in the EU and the UK. Data flows are going to be pretty important. You need to understand where your data is going and then put into place appropriate and potentially additional safeguards. And I think the other things to think about are language in contracts, language in privacy notices. You need to make sure you are referring to the right piece of legislation. You will tend to find that most of your contracts at the moment are referring to EU legislation. And I think over time that needs to be changed to ensure that you refer to UK legislation. And similarly in privacy notices, make sure there is a change, both in terms of the legislation you refer to, but also to make sure that you are picking up and explaining data flows from the UK to the EU, which previously you wouldn't necessarily have been dealing with expressly in privacy notices. And I think that's quite enough on the legal side, and I'm going to hand over to Abraham and Stephanie, who are going to talk about sort of technology-based solutions which can be deployed both to comply with the GDPR, but also to tackle some of the problems raised with the UK leaving the EU.
Thank you, Nick and Selina, for that practical advice from a legal perspective on the impact of us leaving the EU. As you say, there are technical aspects to the compliance with GDPR, and these still apply, even though we're no longer part of the EU. The regulations on the requirements for technical compliance are enshrined in Article 32 of the regulations, which most of you will be familiar with. Hopefully, this presentation will serve as a reminder of what's needed or may jog you into action if you're lacking in any part. Article 32 sets out the technical and organisational measures that organisations should implement to protect the personal data that they store. The regulations don't go into specific detail about what these processes should look like because best practices, particularly when it comes to technology, changes rapidly, and what is considered appropriate now might not be in a few years. However, what is absolute is that any measures you implement should focus on the security of processing, which is Article 32's subheader. That means looking at the ways you store and protect personal data, and particularly at preventing data breaches, as well as physical or technical incidents. There are many other factors that go into GDPR compliance, such as your level of transparency with data subjects and your purpose for processing their information, but these concerns can be put aside for the moment. To comply with Article 32, you need to identify and mitigate risks that are presented by data processing. The way the Article 32 expresses it is to mitigate, in particular, from accidental or unlawful destruction, loss, alteration, unauthorized disclosure of, or access to personal data transmitted, stored, or otherwise processed. So how can you do that? Well, let's take a look. Can I have the next slide, please? Article 32 splits the technical requirements into 4 basic requirements. The first is the pseudonymization of personal data. You can do this by replacing the names and unique identifiers of data subjects with a reference number, which you can cross-reference via a separate document. This way, the information poses much less risk if it's exposed. This is a relatively simple approach to data security, but it's important to remember that it only helps to a certain extent. Indeed, should someone hack into your systems, they may well be able to find the corresponding data set and identify the data subjects. As such, some organizations might decide to go the extra mile and encrypt the personal data. As with pseudonymization, encrypted data is unreadable unless you have another piece of information, which in this case would be a decryption key. However, the extra security that this causes makes it more inconvenient to access the data. So you probably wouldn't encrypt a database that you are using regularly. This process is much better suited to archives, files that you only occasionally access, or data that's being transferred, or information that's stored on devices where the risk of exposure is particularly high, for example, such as on portable devices. Can I have the second area that Article 32 focuses on is the measures to protect the confidentiality, integrity, security, and availability of personal data. Confidentiality refers to the assurance that information is accessible only to authorized parties. Integrity is assurance that information remains accurate, and availability is assurance that the information can be viewed whenever necessary. When it comes to confidentiality, there are 2 things you must look at. The first one is how to prevent criminal hackers from breaking into your systems, and the second one is to prevent your employees from exposing sensitive information. The first issue can be addressed with defenses such as anti-malware software, staff awareness training, and vulnerability scans. The second one you can overcome by reducing the risk of employees misusing the data by creating strict policies on data handling, with an emphasis on disposing of information properly and implementing appropriate defenses when data is stored in the cloud, as well as measures to prevent employees from misusing information maliciously. Data integrity can be ensured with measures such as access controls and audit trails. Can I have the next slide, please? The third area that Article 32 focuses on is the measures to restore data in the event of a disruption. In the event of a physical or technical incident that affects your ability to operate, you must be capable of restoring access to personal data promptly. This is particularly important because, as you probably know, if there is a subject access request, you need to respond to that within a limited time frame. You can do this by creating and regularly maintaining offsite backups, which will prevent data loss. This will be complemented by an incident response plan, which ensures that you can switch to backups with minimal delay. Can I have the next slide, please? And the final area of Article 32 is the ability to regularly test the effectiveness of the measures that you put in place. You must be confident that the technical and organisational measures that you've adopted continue to work as intended. It may be that your organisational structure has changed, and that may affect the way that those processes work. So it's important that you keep those up to date. A review of your measures might reveal that the processes that you have in place aren't being followed properly. It may reveal that your technology is faulty or the risk has evolved. Interestingly, in speaking with a lot of IT managers, it's amazing how many of them, when it comes to backup of data, do so with their fingers crossed behind their backs. Whatever the issue might be, you must regularly test any technical or organisational measure that you adopt. This might come in a number of different forms, for example, an audit, a vulnerability scan, a penetration test. These are all examples of how you can do that. So on that note, I'd now like to hand over to the final section of this presentation, which is being handled by my colleague, Stephanie.
Good morning, everyone, and thank you for that, Abe. As Abe mentioned, my name is Stephanie, and I would like to give you a slightly broader view of Toshiba Tech and what we can help with in terms of technology needs, specifically in relation to the topic of today. So the areas where we can be of particular assistance is the supplementary measures as it relates to technology that Nick mentioned, and also that is one of the 6 principles that Selina mentioned, which is appropriate security. So as well as conforming to the advice within Article 32, we can also help you put the technology blocks in place to run an IT environment that will provide you with the 4 things that Abe mentioned, which is confidentiality, integrity, security, and availability of your data. Now, you might have some of these things in place already, but if you're not sure and you want to check if anything is missing, and you are concerned about any security certifications that you need to require, or are not sure if you conform to some of the regulations, we can help you with the security assessment or a pre-audit, if you want to call it that. And we can then advise you where there are gaps in your technology processes or user behavior, and typically things that might prevent you from getting certified or conforming to a specific set of requirements. So Toshiba Tech can advise you, provide, implement, and then support these technology solutions, which could typically consist of hardware, software, processes, which include things like data flow or mapping your data flow, and support, ongoing support for those processes to keep it up to date and to keep it in place. And as a result of a security assessment or a GDPR audit, which we can also do, we will then produce a set of recommendations which we can then help you implement. So apart from technology requirements, if you are not a large organization and you cannot afford to appoint a full-time DPO or 1 or 2 GDPR reps, we can also assist with a virtual or part-time DPO or GDPR rep service. So my main message to you today is come and talk to us at Toshiba Tech. We will listen to your requirements and to what you're concerned about in terms of data. Is it confidentiality, integrity, security, availability, so backup and disaster recovery, all of those things. And we can help you fill these gaps or identify the gaps that need filling. And in that way, we can help you grow your client base because you'll be eligible to take on more contracts and thus build your business. It will help improve your brand and it will avoid you getting any fines. So on the next 2 slides, You will find the contact details of both Edwin Co and Toshiba Tech for any further information. So there you will see Nick's contact details and Selena's contact details. And the one after that would be myself and Abe. And as I'm sure you understand, Edwin Co can be contacted for any assistance on legal advice or legal matters or contracting standard clauses, all of those things, privacy notices. And Toshiba Tech can be contacted for any technology requirements, mapping processes, doing security assessments, etc. So we would very much like to hear from you. Thank you. And now I pass back to Selena. Thanks.
Thanks, Stephanie. So just to wrap up, we've got a few minutes now, just take a couple of questions, and I've been sort of monitoring the questions to come in. So thank you for submitting them. And obviously for any questions that we haven't got time to get to, if you'd like to ask either myself, Nick, Stephanie or Abraham, then feel free to get in touch with us at the end of the session. But I'm going to kick off, and if it's okay, I'm going to direct this one to you. The first question that's been asked is, we understand that it's not necessary to back up my Office 365 mailbox. Is this the case?
That's a good question, and we've come across that question and amongst many of our customers and amongst many people who are talking to us at the moment. Microsoft themselves say that they protect the environment that your data sits in, but they don't actually protect the data that you put in that environment. So essentially what they're saying is that it's important that you back up your any data that you hold in your Office 365 mailboxes. And they do recommend that you go to a third party for backing up your Office 365 mailboxes. Hope that answers that question.
Thank you. And the next question that's come in, Nick, I might direct this to you if that's okay. So Tom has asked, does the UK recognise the US data privacy shield?
No, it doesn't. So the UK is essentially following the EU on this. So the CJEU, the Court of Justice of the European Union, has declared Privacy Shield to be invalid. That's the sort of the whole thrust of the Schrems II judgment. So Privacy Shield falls away, and it falls away both for the EU and the UK for practical purposes. I think this is exactly the sort of thing which the EU doesn't want to happen. So the UK could take it upon themselves to start recognising Privacy Shield, so not to follow the CJEU, and then you'd have a sort of slightly awkward situation where you could move your EU data into the UK and get it out to the US, and you wouldn't have that sort of same level of protection. So the simple answer is no, it doesn't, and you've got to look at some other form of safeguard if you're moving data from the UK to the US.
Thank you. I mean, we are slightly out of time, so but those who can hang on just a little bit longer, I might ask just a couple more questions. I think someone's asked, my company is headquartered in the UK, so the ICO was its one-stop shop, but they have 8 subsidiaries in 8 member states. How do we choose which member state for the one-stop shop? So I'll take this very, very quickly, and I think the answer is that ideally you want to choose the supervisory authority as your lead authority in one of the member states where you have your largest customer base or where most processing is happening. I mean, if it's across all 8, you just need to carefully consider what type of processing is taking place, and you need to decide which member state in which you will appoint your lead authority. But yeah, mostly it's down to where you have your most customers. And I think I'm just going to ask a very quick question to Nick, again to you, if that's okay, or me. Can I be fined both under the UK and EU GDPR? Which is quite a nice succinct question.
Yeah, I think unfortunately the answer is yes. So you've got two regimes going here. If you're so as I said, you're covered by the UK regime insofar as because you're a UK business, and insofar as your processing relates to the UK. So could well be fined by the ICO if you get it wrong on that level. But you could also be pulled into the sort of EU GDPR jurisdiction where your processing relates to activities in the EU. So you could easily be fined under that regime as well. I suppose if you think about some kind of security breach, data breach, it's unlikely to be specific to just the UK part of your business or just the EU part of your business. So I think it's actually quite likely that if there was a major security problem, you would potentially being hit by at least inquiries, possibly fines from both the UK ICO and from supervisory authorities based in the EU.
Perfect. Thank you. Okay, well, thank you for that, Nick, and thank you to Stephanie and Abraham. I think that's all we have time for today. So to wrap up, I just want to thank everyone for attending. I hope it's been very useful. I believe this webinar has been recorded and will be made available to you. There's also a feedback form that will be presented after the webinar. So if you don't mind filling that out, that would be much appreciated. Okay, well, thank you very much for attending and have a lovely day. Bye-bye.